Um, If you're elected, and this question is to all three of you, if you're elected, will you promise to either identify those individuals and collect that information through the paperwork, or ask everybody that comes through to your department? Yes or no?
Well, since I am a judge currently, what I can promise and is I can sit down with your organization and have a detailed discussion as to the information you'd like me to collect, and I could see what I can tell you right now. They have just started an e-filing system where everything's done paperless. It has caused a huge headache for my own assistants in the court system to file a motion. Sometimes I'm not getting it back a week later, and it's causing a lot of headaches right now. So I don't want to necessarily put an additional burden right now on my staff because of what's going on. I'm sure the attorneys are experiencing the same headaches that I am. But to the extent that I can sit down, we can talk to you. If there's something that we can implement, I'd be willing to do that.
This is John Eccles. You'd ask for a yes or no question, and I'll do the best I can with that. I would say no, but not for any negative particular reason. I'm a veteran, and I'm not sure that the fact that somebody's a veteran would directly play into the division of assets or debts or the custodial arrangement. So I don't know that it's particularly relevant, but that doesn't mean that I wouldn't be interested in having somebody tell me that they're a veteran if they felt that that was important to them.
Thank you. Ellen Bezian. I think it's significant and important information that each attorney should disclose in their pleadings. I have never drafted and filed a pleading that I did not state, probably in the first two sentences, that I'm representing a veteran. I'm representing an active member of the military. And so I think first it starts with the attorneys. And I think that needs to get out. Any attorney who doesn't draft that is probably falling down in terms of their advocacy for that party's position. As a judge, I don't know that it would be ethical for a judge to make a promise or place any weight on someone being a veteran versus being a police officer versus being a firefighter. So I don't know that we could do that, but absolutely I'd be willing to do whatever I could so that the litigant received the respect that he was due for having served this country, and also so that he would not or she would not be punished or undervalued in any way in terms of deployment and suffer any consequences in a custody issue. So to that extent, yes, I would absolutely do everything I could.
Hi, David Rivers. The oath of office that Your Honor has taken, that each of you would take if elected as a judge, is found in Article 15, Section 2 of the Nevada Constitution. It ends with the words, either "so help me God," or "under pains and penalties of perjury." Tell me what your belief is as to your, excuse me, your understanding and your obligations under the oath, and the penalties for violating those obligations.
David, this is Judge Bill Gonzalez, and I think first and foremost, as judges, we are to follow the law. And when you take an oath, that is a legal oath that you are taking. I believe it's also a moral oath that you're taking. And for me, that's probably one of the greatest weights one of the most important things that I've done is taken that judicial oath. And I think as judges, we have an ethical, we have a fiduciary duty to the community to live up to that oath. To the extent that a judge would violate that oath, there's procedures where you could be removed from office, and we've had individuals in our community who have been sitting on the bench that have been removed because they have violated that oath and that trust that you're given. It is a great trust that you're given as a judge. You are making judgment that affects lives, that you could take somebody's children away from them, where they would not be able to see their own children. That is a weighty, weighty matter in life. When you're talking about civil cases where it's all about money, if it's a divorce case and these people are never going to see each other again and you're just splitting up property, those are easy cases. But when you're looking at, families and the important thing to do, that is a very, very weighty matter. And what I can say is, just adding to that, I'm in the courtroom at 6 o'clock in the morning every day. I prepare for calendars. There is not a case that I don't believe is important in my eyes, and I believe that is part of that oath that I take to make sure that every litigant has a fair day in court and that they're treated with respect, that you follow the law, and that you try to the best that you can to be fair. And again, if I'm not doing that or a judge is not doing that, I think that we should be taken off the bench, because that is an obligation that you have, and if you violate that sacred trust with the community, you shouldn't be sitting there.
To a large degree, I'd have to agree with Judge Gonzalez that the basic and the most essential premise is when you take the oath of office to be a judge for the Clark County constituency, if you breach that obligation to your constituents, and it's determined by people probably much smarter than we are, that you are no longer fit to maintain that office, then you should be removed. I can't think, just as your oath when you go into military service, if you can't meet your obligations, you should be removed from office.
Thank you, Ellen Bezian. I almost want you to repeat those two statements that you made, because I think they're equally profound. Under penalty of perjury means there is a consequence if you have misled, lied, or misrepresented to the court. That's relevant because not everyone believes in God. And I think people are entitled to whatever their beliefs are, so long as they know that there is a consequence for misrepresenting or lying, just to let go of that euphemism. So I believe that both of those statements are important, and I think that they should be stressed, whether it's a party who signed an affidavit, whether it's a party who's sworn in open court. I think that it should be a moral as well as a legal obligation that they have to provide the facts as they are, and it's a judge's duty to get to the facts, and that's done through, of course, evidence, witnesses, and other things. Thank you.